So let's continue with causation, and now we're getting into our first type of water. So causation continued, water types, surface water. What are surface waters? Well, the case law is confusing, like I said. And so when you look at these cases and when you look at your case, one of the first things you need to ask is, well, if you're dealing with water damage to the property, what type of water was it? Right? What type of water? So surface water are defined as rainwater diffused over land surface, right? So what's the rule when you're dealing with surface water? As you can see, there's a nice picture of some heavy rain here. The rule is this: the owner of the lower parcel, remember Archer, is expected to accept the natural drainage from the upper parcel. That's what's known in water law as a natural water course rule, all right? What happens, however, when the upper parcel owner changes the drainage and diverts the surface water? Well, in that case, the upper property owner is liable to the lower property owner if the upper property owner acted unreasonable. All right. Now, case law, looking with these facts, indicates that government, public entity, as the upper property owner, can avoid inverse condemnation liability if it acted reasonably, especially if the lower property owner acted unreasonably. So again, now you start to see Bel Air being applied outside of a flood control context, in the context of surface waters, right? Because we're not talking about flood water at all. We're not talking about flood control projects. Now,
the first code is 831. The first code is 831. The first code is 831.
Where it gets a little muddled as well is a case law, although it uses the terms reasonably, it doesn't mean reasonableness in like what you see in negligence cases. It's different. The case law speaks to a weighing of interest and behaviors. That's what they're talking about here. So let's move on to a second type of water. So causation continued, water types, stream waters. What are stream waters? Well, you see here in the picture, got a nice picture of a tranquil lake with a couple of ducks doing their thing. So what is stream water? It's water flowing in a fixed channel, okay, a river or a lake like what you see here. So what's the rule? Well, it's very similar to the surface water rule. The traditional rule was that one diverting stream water from a fixed channel to adjacent land is liable, right? That rule is applicable to public entities in inverse condemnation. Now, according to case law, there's inverse condemnation when construction by a public entity of a public project, for example, a dam, a levee, dikes, a culvert, or a canal, alters the flow of water in its natural channel. So getting back to this picture here of the lake, let's just say the city decides to build a culvert for, to drain the water, to do some type of public project. Let's say they want to implement a new development. And in doing so, it floods the owners of adjacent property. Case law says inverse condemnation. Okay, that's an inverse condemnation case. Also, according to case law, there's inverse condemnation in this context when damages are caused by the operation of the improvement as designed. So let's go back to this example I said by putting some type of canal on the side of this lake here. If it's operating as it's designed, as intended, and it causes damage to the adjacent property owners, inverse condemnation. What's interesting, again, to California practitioners, is you may know if you're dealing with either suing or defending public entities under the Government Tort Claims Act, you'll come up against design immunity, right? Which I would say is a very potent defense by the public entities. But again, knowing that we're outside of that context, what's interesting here is, according to case law, there is no, design immunity. Now, I know I said that we're outside of the context of the California torts claims, and we are, but it's very interesting to see that in this context, there's, design, doesn't matter if it's operating as designed, there's inverse condemnation. So what's an example of this? Well, I think there's a case that speaks about an entity removing dikes from the river and replaced it with levees. Okay, that caused damage. Court said inverse condemnation. Another example is when you have a building of levees for flood control purposes and that diverts water into private property, inverse condemnation. Older cases have dealt with the concept of foreseeability. You'll see that in the older cases, right? But more recent cases have departed from that analysis. Likely, if you have a case like this, if you're trying to analyze it, you're going to be stuck with Lachlan. So I have that mentioned here. So what's Lachlan about? Okay, this is an important case for our purposes. In Lachlan, the government constructed a storm drain, several systems of it, and made changes to the upstream property that caused increased volume of water into the natural watercourse, damaging downstream private property. So what am I talking about here? What I'm talking about is the facts of this case. The government had upper partial property. They constructed storm drain facilities on that property. What that did is it caused an increased velocity of water that was in a body of water, stream water, and it flooded the downstream private property owners. So this case was brought before the Supreme Court, and the Supreme Court held that the rule was whether or not the upper parcel owner, the entity in this case, whether their conduct was reasonable. All right? So we talked about that earlier. That's a natural watercourse rule, and they applied it to public entities. They rejected the Archer analysis, which we talked about. And like I said, I think there's an argument to be made that Archer is no longer good law. And instead, the court came in and said, well, we recognize what was discussed in Bel Air, and that there's an argument to be made that there's an unanswered question as to how do we understand what's reasonable? How do we gauge whether or not an entity was unreasonable in what they did? So the court in Lachlan gave the Lachlan factors. So the Lachlan factors are: you look at whether or not the public purpose is being served by the project, the cost of the project, the benefit of the project, the availability of alternatives, the severity of damages, the expected risk, and the degree to which the damage affected the plaintiff. You take a look at all those factors and you weigh them together, and then hopefully you reach a conclusion as to whether or not the entity was unreasonable and therefore liable for inverse condemnation. Now, something interesting about Lachlan is that Lachlan is limited to property adjacent to watercourse. So let's go back to this example. Let's just say that the city builds a culvert or a canal outside of this lake, diverts the water, and it floods neighbors. They're not adjacent property owners, but neighbors down the way. In that case, there's an argument to be made that the Lachlan reasonableness analysis doesn't apply, that you're back to traditional strict liability analysis.